everyone, this is Nazarat Fatima and you're watching LiveLaw. As we know, the Medical Termination of Pregnancy Act was enacted keeping in view the physical and mental health of women and also their right to life, which has been protected under the Act. But there can at times be complicated situations where it becomes difficult to assess whether providing any relief under the MTP Act shall practically be of benefit to a woman or not. The Calcutta High Court was faced with a situation where a minor girl aged 12, a victim of rape, was 25 weeks pregnant with twin fetuses. The mother of the victim filed a writ petition praying for the termination of pregnancy of her minor daughter. She sought permission from the court to terminate the unwanted pregnancy, but the court did not permit it because such termination involved a risk to the extent of maternal death. The matter was heard by Justice Aniruddha Roy, who observed that, as per the report of the medical board, the termination of pregnancy at this stage of gestation can put the minor girl's life at risk, and the court cannot neglect that aspect. He said, and I quote, "In the light of the said report furnished by the medical board, one crucial factor is there, of which this court cannot be unmindful, that the termination of pregnancy at this stage of gestation may carry a risk even to the extent of maternal death. Here this court got stuck, as the life of the minor girl is paramount at this stage. If ultimately the minor girl has to sacrifice her life in the event of termination of her unwilling pregnancy at this advanced stage, then the question automatically comes to the mind of this court that whose personal life, liberty and dignity shall be protected as guaranteed under Article 21 of the Constitution. For those reasons and discussions, this court cannot proceed to grant any relief for medical termination of the pregnancy of the said minor girl." The court also emphasized over the mental health of the victim and said that this court needs to ponder at this stage as to whether continuance of such unwilling pregnancy would involve a risk of causing grave injury to the mental health of the minor girl and whether the constitutional safeguard for protection of life can be extended to her. If so, to what extent? It also observed that constitutional protection of life and liberty, including leading a life without any phobia, fear, trauma, and with dignity, had been statutorily recognized and falls within the Medical Termination of Pregnancy Act 1971. The court said that the statute also provides for mother's health, strength, and life. Just by giving birth out of an unwilling pregnancy, rest of the life of the mother cannot be in a compromised existence. Keeping in view such facts, the court held that it cannot proceed to grant any relief for medical termination of the pregnancy of the said minor girl. However, the court directed that the concerned hospital should take all possible medical care and all steps for the necessary treatment and medical assistance required for the minor girl and the fetuses without any negligence. And as such, the court disposed of the writ petition. To read more on the topic and go into the details of the judgment, visit our website and click on News Updates. Thank you for watching.